3 days ago, she sent it from the home she grew up in. Your eviction notice, forwarded from a lawyer you never met, attached with a smiley emoji. White beard, gray shirt, porch you built with your own hands now blurred behind you. And the title, transferred a month ago without your signature, your daughter, your name erased. But she doesn't know you filed the quiet claim last year, and she already hit send. This is the story of a man who spent 35 years building a home, only to discover his daughter had already sold it out from under him. But it's not just his story. Every year, 1 in 10 Americans over 60 falls victim to financial abuse, most often from the people they trust most. His case is unusual only because he noticed in time, and because he planned for this exact moment years ago, without telling anyone. The question that drives this documentary isn't whether he'll win the legal fight. It's whether he can ever trust his own blood again. His name is Arthur Hale. For 35 years, he lived on a 5-acre plot in rural Pennsylvania, land his grandfather homesteaded in 1942. Arthur built the house himself, framed every wall, laid every floorboard, wired every outlet. He raised 2 children there, buried his wife there, and assumed he would die there. That assumption became the foundation of every decision he made for the last decade of his working life. His daughter, Sarah, was always the sharp one. Valedictorian, then a law degree from a top-tier school, then a partnership track at a Philadelphia firm by age 32. Arthur was proud, the kind of proud that made him sign whatever she put in front of him without reading the fine print. Tax documents, power of attorney, a revocable living trust that she said would protect the property from probate. He trusted her completely, the way parents trust children who have never given them a reason to doubt. That trust was the only tool she needed. Elder financial abuse rarely looks like a crime in the moment. It looks like a daughter helping her aging father manage his affairs. It looks like efficiency, like convenience, like love. The National Council on Aging estimates that 1 in 10 Americans over 60 has experienced some form of elder abuse, and 90% of the perpetrators are family members. The average victim loses $120,000 before anyone notices. Arthur would lose more than money. The first red flag came in 2019, when Sarah suggested Arthur sell the property to her for $1. She framed it as estate planning, a way to avoid inheritance taxes. Arthur hesitated. He mentioned it to a neighbor, a retired real estate attorney named Frank Delgado. Frank told him that selling for $1 to a family member could create tax problems, but more importantly, it transferred all control. Arthur listened, thanked Frank, and told Sarah he wasn't comfortable. She smiled, said she understood, and did not bring it up again. But she also did not stop thinking about it. Over the next 3 years, Sarah slowly consolidated Arthur's financial life under her management. She became the sole signatory on his checking account. She refinanced the property through a company she controlled, taking out a $70,000 home equity line that Arthur never saw. She used the money to pay off her own credit card debt and fund a renovation on her primary residence. Arthur did not question the monthly statements because he trusted his daughter completely. In June of 2023, Sarah filed a quitclaim deed transferring the property from Arthur to herself. She used a notary public who was a friend from law school. The document listed Arthur's signature, but it was not his signature. Handwriting experts would later confirm that the slant, the pressure points, the loops of the letters did not match any of Arthur's known signatures. But the county recorder's office did not check. They simply stamped it and filed it. Arthur did not learn about the transfer for another 11 months. He discovered it by accident. In May of 2024, he received a property tax bill addressed to Sarah Hale. He opened it without thinking. The bill listed the owner of record as Sarah Hale, not Arthur Hale. He sat at his kitchen table for 20 minutes staring at the paper, trying to make the words rearrange themselves into a mistake. They did not. He called Frank Delgado. Frank pulled the deed records from the county website. The quitclaim deed was there, dated June 15, 2023, signed by Arthur, notarized, recorded. Frank asked Arthur if he had a copy of his signature from around that time. Arthur found a check he had written the same week. The difference was obvious to anyone who looked. Frank told Arthur to file a quiet title action immediately, a legal procedure to establish ownership and clear the fraudulent deed. Arthur filed the quiet title action in July of 2024. He did not tell Sarah he had done it. He did not tell any of his other children. He kept the documents in a fireproof safe that had originally held his wife's jewelry. For 8 months, nothing happened. The court process moved slowly. Sarah did not respond to the initial filing. Arthur waited, worked his garden, watched the oak tree his wife had planted grow another ring. On the surface, life continued normally, but Arthur had started documenting everything. Every call with Sarah, every visit. Every time she mentioned the property. Every time she hinted that he should move into a retirement community. Every time she said the house was too much for one person to maintain. He wrote it all down in a spiral notebook, the same kind his father had used to record crop yields in the 1950s. In March of 2025, the quiet title action finally reached a hearing date. The judge set it for April 14th. Arthur told himself he had everything he needed. He had the forged deed. He had the comparison signatures. He had a witness who remembered the conversation about not selling for $1. He did not have the one thing he needed most. He did not have a confession. On March 28th, 17 days before the hearing, Arthur received a text message from his daughter. It was a photograph of a legal document. It was a notice of eviction issued by the county sheriff's office, ordering the occupant of the property known as 1472 Hickory Lane to vacate within 30 days. The occupant was Arthur. The owner requesting the eviction was Sarah Hale. Below the photograph, Sarah had typed 2 words. "Sorry, smiley face." Arthur read the message 3 times. The eviction notice was real. The sheriff's office had stamped it, signed it, and logged it into the county system. His own daughter had filed the paperwork. The smiley emoji sat beneath the words like a punctuation mark designed to make cruelty feel casual. Arthur did not reply. He did not call Sarah. He picked up the phone and dialed Frank Delgado. Frank told him to do nothing. The eviction notice was a pressure tactic, not a legal inevitability. The quiet title action was still on the calendar for April 14th. If Arthur voluntarily moved out, even for a day, that could be used against him as acknowledgement of Sarah's ownership. The law is technical. Possession still matters. A single week of vacancy can shift the entire argument. Arthur stayed. But staying meant watching for the sheriff every morning. It meant answering the door with his phone recording. It meant sleeping in the same clothes so he could get up fast if the knock came at dawn. He told his other daughter, Emily, what was happening. Emily lived in Oregon. She had always been the quiet one, the one who didn't go to law school, who married a carpenter and raised 3 kids in a house half the size of Arthur. She flew to Pennsylvania on the first flight she could get. When Emily walked into the house, she looked at her father and said something that hit him harder than the eviction notice. She said, "I knew she was doing something. I just didn't know what." Emily explained that Sarah had changed over the last few years. Not all at once, but in increments that were easy to miss if you were far away. Sarah had stopped coming to holidays. She had started talking differently about the family property, calling it a burden, saying it was unfair that Arthur had so much while others struggled. She had asked Emily several times whether Arthur still seemed sharp, whether he was forgetting things, whether anyone had power of attorney. Emily had answered vaguely, not realizing she was being surveyed. Arthur listened and felt the shape of something he had refused to name. The exploitation had not started with the quitclaim deed. It had started years earlier, with groundwork, with questions designed to build a narrative that Arthur was losing capacity, with legal documents signed in haste, with a daughter who knew exactly which levers to pull. The legal system favors the prepared. Sarah had prepared, Arthur had not. On April 2nd, 12 days before the hearing, Arthur received a notice from Sarah's attorney. It was a motion to dismiss the quiet title action based on lack of standing. The argument was technical. Arthur had signed the quitclaim deed voluntarily, and even if the signature was not his, he had failed to object within a reasonable time frame. 11 months between the recording and the filing, Sarah's attorney argued, was unreasonable. The motion cited a Pennsylvania statute that required challenges to forged deeds to be brought within 6 months. Arthur's attorney countered that the statute of limitations began when the victim discovered the fraud, not when it was recorded. The judge would decide. The motion was not Sarah's only move. That same week, Arthur received a certified letter from a bank he had never heard of. It was a notice of default on the home equity line Sarah had taken out in his name. She had stopped making payments 3 months ago. The balance was $72,000. The bank was threatening foreclosure. The address on the mortgage was the property Arthur lived in. This is a common tactic in elder financial abuse cases. The perpetrator extracts equity from the property, then stops paying, forcing the victim into a choice between financial ruin and legal surrender. The elder either pays the debt they never authorized or loses the house to foreclosure. Either way, the perpetrator gains leverage. The bank does not care who signed the papers. They only care about the money. Arthur did not have $72,000. His savings from 35 years of construction work had been depleted by medical bills from his wife's illness, and by what he now realized were Sarah's withdrawals from the joint checking account. He had maybe $20,000 left, enough to pay a lawyer for a few more months, not enough to stop a foreclosure. He called Frank again. Frank told him that the foreclosure process would take months, maybe a year. The quiet title action would resolve ownership first. If Arthur won the deed challenge, the mortgage could be invalidated because it was obtained through fraud. But if he lost the quiet title action, the foreclosure would proceed and Sarah would own nothing either. The bank would take everything. It was in that moment, sitting in his kitchen on a Tuesday evening in early April, that Arthur made a decision that would reframe everything. He had been playing defense. He had been reacting. He needed to go on offense. He reached into the fireproof safe and pulled out a document he had never shown anyone. It was a handwritten note, dated November 15, 2022, signed by Sarah. The note had been written during a conversation about the property, when Sarah had asked Arthur to sign a different form, one he had refused. In frustration, she had written out a series of promises she claimed she would honor if he cooperated. He had kept the note. The note read, "I will never transfer the property without your consent. I will never use the property as collateral without telling you. I will always put your needs first." It was signed, "Love, Sarah." Arthur had never mentioned the note to Frank. He had never mentioned it to Emily. He had kept it because some part of him had known that he might need it, the way his father had kept old ledgers from years of bad harvests, not because they were useful, but because they were proof. He called Frank and read the note over the phone. Frank was quiet for a long time. Then he said, "That changes everything." The note was not a contract. It was not notarized, but it was evidence of intent, evidence that Sarah had represented herself to Arthur as trustworthy while doing the opposite. Pennsylvania law recognized fraudulent misrepresentation. The note, combined with the forged deed, the home equity line, the eviction filing, and the smiley face text, painted a pattern of deliberate deception. Frank filed an amended complaint that included the note and added a claim for intentional infliction of emotional distress. He also filed a motion for a temporary restraining order to stop the eviction until the hearing. The judge granted the TRO the same day. Arthur was allowed to stay in his home until April 14th. The TRO bought him time, but it also did something unintended. It made the story public. The motion papers were filed with the court, which meant they became part of the public record. A reporter from the local newspaper, the Sentinel, noticed the filing and called Arthur for comment. Arthur declined to speak. The reporter called Sarah. Sarah did not respond. The story ran on the front page of the Sentinel's April 4th edition. It included the basic facts: an elderly man, a forged deed, an eviction notice delivered via text with a smiley face, a pending court hearing. The reporter had obtained a copy of the text message through a public records request. The smiley face became the focal point of the story. It was the detail that made people angry. Within 24 hours, the story went regional. A Philadelphia TV station picked it up, then a national cable news segment. Arthur's phone began ringing constantly. He stopped answering. Emily handled the calls, telling journalists that her father wanted privacy until the hearing. But the attention changed the pressure. Sarah's law firm, a mid-sized Philadelphia practice that specialized in estate planning, placed her on administrative leave. A spokesperson said they were investigating the allegations. The firm did not say whether Sarah had used company resources to prepare the quitclaim deed or the eviction filing. They would not confirm whether she had used firm notary services. They simply said she was on leave. Sarah did not contact Arthur. She did not call Emily. She went dark. The only sign that she was still engaged came on April 6th, when Arthur received a one-line email from her personal address. "Drop the case and I'll walk away. No interest in the property. I'll sign whatever you want." Emily wanted Arthur to accept. She said it was the safest path. No trial, no risk. Sarah would vanish from their lives and Arthur could stay in his home. But Arthur had learned something in the last week. He had learned that the property was worth roughly $400,000. He had learned that Sarah had already taken out $70,000 in equity. He had learned that she had tried to evict him and failed. And he had learned that the note she wrote in 2022 was not the only document she had ever signed. He pulled out a second document from the fireproof safe, one he had forgotten about. It was a promissory note dated 2018 for $30,000 that Sarah had borrowed from Arthur to start her law practice. She had never repaid a single dollar. The note was unsigned. Arthur had given her the money in cash, but the paper existed and it showed her handwriting, her promises, her pattern. Arthur looked at Emily and said, "I'm not dropping the case. I want her to lose everything." The hearing was 8 days away. Sarah had gone silent. The bank had filed a notice of intent to accelerate the mortgage. The sheriff's eviction notice was stayed. The news vans were parked at the end of the driveway. Inside the house, Arthur sat at his kitchen table with Emily and Frank, reviewing the documents one last time. Frank pointed to something none of them had noticed before. The quitclaim deed listed the property address as 1472 Hickory Lane, but Arthur's property had never been 1472 Hickory Lane. The address had always been 1474. Sarah had filed the deed with the wrong house number. Frank called the county recorder's office the next morning. The clerk confirmed that the property at 1472 Hickory Lane was a vacant lot owned by a timber company. The quitclaim deed that Sarah had recorded transferred ownership of the wrong piece of land. The deed was invalid on its face. Arthur had spent 8 months fighting for a house that his daughter had never actually stolen. The house was still his. The forged deed was worthless. But Sarah did not know that yet. Arthur sat with the knowledge for an hour before deciding what to do. The quitclaim deed was recorded against a vacant lot owned by a timber company. Sarah had stolen nothing. The house at 1474 Hickory Lane was still his, legally and completely. But Sarah had committed forgery, fraud, and filing a false document with the county recorder. She had also attempted to evict him from a property she did not own and never had. Frank advised Arthur to say nothing until the hearing. Let Sarah argue her case. Let her continue believing she held the deed. The hearing was 5 days away. Arthur agreed. But on April 9th, 3 days before the hearing, Sarah discovered the mistake. She filed a corrected quitclaim deed, this time with the right address, backdated to June 15, 2023. The county recorder accepted it without question. Clerks process thousands of deeds a year. They do not verify signatures. They do not check dates. They stamp and file. Frank learned about the corrected deed the same day through a routine alert he had set up on the county recorder's website. He called Arthur immediately. The corrected deed changed the legal landscape. The wrong address had been Arthur's strongest technical defense. Now it was gone. The case returned to its original question: was the signature forged? Arthur had never provided a handwriting exemplar to the court. He had mentioned the comparison check to Frank, but they had never formally submitted it. Frank told him they needed one immediately, a clean sample of Arthur's signature from around June of 2023, witnessed and notarized. Arthur found an old property tax payment with his signature dated May 24, 2023. He signed a new exemplar in front of a notary at the bank, and Frank filed it that afternoon. The corrected deed also told Arthur something he had not fully understood until that moment. Sarah had access to the county system. She knew how to track filings. She had discovered the wrong address not through a random check, but because she was monitoring the case file. She had a contact inside the recorder's office, a clerk she had worked with during her estate planning practice. Arthur would learn later that Sarah had asked this clerk to flag any filings related to her name or Arthur's name. The clerk had complied. It was not illegal. Clerks provide public information to anyone who asks, but it gave Sarah an advantage Arthur had not anticipated. On April 10th, 2 days before the hearing, Sarah's attorney filed a motion to compel arbitration. The motion argued that the promissory note Arthur planned to introduce as evidence contained an arbitration clause. It did not. The note was handwritten and unsigned, but the motion created confusion and forced the court to spend time deciding a procedural question instead of the substantive one. Frank called Arthur and said something he would remember for the rest of his life. He said, "She is not fighting to win. She is fighting to exhaust you. She knows she will lose on the merits. She is trying to make you quit because it is easier than fighting." That same evening, Arthur received a text from an unknown number. It read, "Drop the case or the house burns," no punctuation, no context. Arthur reported the text to the police. The responding officer told him there was little they could do without identifying the sender. Arthur gave the officer the number. The officer ran it. The number was registered to a prepaid phone purchased at a convenience store in Philadelphia with cash. Untraceable. Arthur did not sleep that night. He sat in his living room with a shotgun his grandfather had carried in World War I, watching the driveway through the front window. Emily slept on the couch. The news vans had left. The road was dark. Nothing happened. The morning of April 11th, the day before the hearing, brought 3 developments that reshaped everything. The first development was a letter from the Pennsylvania Bar Association, addressed to Arthur, informing him that Sarah had voluntarily surrendered her law license pending the outcome of the civil case. The letter was standard procedure. Bar associations do not wait for convictions. They act the moment public allegations threaten the profession's reputation. Sarah could no longer practice law. Her career, 15 years of building a name in Philadelphia estate planning, was suspended indefinitely. Arthur felt no satisfaction. He felt something closer to grief. The second development was a call from the bank. The home equity line had been accelerated. The full balance of $72,000 was due immediately. If it was not paid within 30 days, the bank would begin foreclosure proceedings on the house at 1474 Hickory Lane. Arthur asked whether Sarah was liable. The bank representative said no. The loan was in Arthur's name. The signature may have been forged, but until a court ruled on the forgery, the bank considered Arthur the borrower. Arthur asked if there was any way to stop the clock. The representative said he could file a dispute with the bank's fraud department. It would take 60 to 90 days to investigate. The foreclosure timeline would not pause. The third development was a voicemail from Sarah, left on Arthur's phone at 6:47 in the morning. Arthur played it for Emily and Frank with the speaker on. Sarah's voice was calm. She said, "Dad, I know you're going to win tomorrow. You have all the evidence, I know that, but I want you to understand something. I did not do this because I wanted your house. I did it because I was drowning. I lost my biggest client in 2023. I took out loans I could not pay. I was going to lose everything. I thought I could fix it before you found out. I thought I could sell the property, pay back what I took, and put the rest in a trust for you. I was wrong. I am sorry. I am not asking you to drop the case. I am asking you to remember that I am still your daughter." The voicemail ended. Arthur did not respond. He looked at Emily. Emily was crying. Arthur was not. He had run out of tears somewhere in the last 11 months. He said to Emily, "She could have told me. Any time in the last 3 years, she could have told me she was in trouble. I would have helped her. I would have given her money. I would have signed over the house if she had asked. But she did not ask. She forged. She lied. She tried to throw me onto the street." Emily nodded. She said, "I know, Dad." On the morning of April 14th, Arthur drove to the county courthouse with Emily beside him and Frank's file in his lap. The building was the same one where he had registered his deed in 1990, the same one where he had paid property taxes for 35 years, the same one where his wife had come to file their marriage license in 1979. Sarah was already there. She stood in the hallway outside the courtroom alone, wearing a dark suit, no briefcase. She looked smaller than Arthur remembered, older. Her eyes met his for a moment. She looked down. The courtroom was small. The judge was the same one who had signed the TRO. The gallery held 4 people: Emily, a reporter from the Sentinel, a law student working for Frank, and a woman Arthur did not recognize. The woman turned out to be an investigator from the Pennsylvania Bar Association, there to observe. Sarah represented herself. Her attorney had withdrawn 2 days earlier, citing a conflict of interest. She stood at the plaintiff's table alone, without notes, without binder, without the stack of documents that Frank had laid across the defendant's table. The judge called the case. Frank presented first. He submitted the corrected quitclaim deed, the original forged deed, the handwriting exemplar, the promissory note, the eviction notice, the text messages, and the voicemail. He played the voicemail out loud. The judge listened without moving. Then Frank presented the quiet title action. He argued that the deed was obtained through fraud, that the signature was not Arthur's, that Sarah had admitted in the voicemail to transferring the property without consent, that the entire scheme was a textbook case of elder financial exploitation. Sarah did not cross-examine Frank. She sat still. The judge asked Sarah if she wished to present her case. Sarah stood. She said, "I have no evidence to present. I admit to the forgery. I admit to the false filing. I admit to the home equity line. I was desperate. I made terrible decisions. I am ashamed. I will accept whatever judgment the court imposes." The courtroom went silent. The judge asked Sarah to clarify. Sarah repeated her statement. She said she was not contesting any of the facts. She said she had prepared a quitclaim deed returning the property to Arthur, corrected and notarized that morning. She handed it to the clerk. The judge reviewed the document. She signed the order granting the quiet title action. She declared the original deed void. She ordered Sarah to pay restitution of $72,000 for the home equity line, plus legal fees. She referred the case to the district attorney's office for possible criminal prosecution. She looked at Arthur and said, "This court apologizes that you had to go through this. You should never have had to fight for your own home." Arthur looked at Sarah. Sarah was not looking at him. She was staring at the table. The entire hearing lasted 23 minutes. Arthur walked out of the courthouse into a cold April rain. The reporter from the Sentinel stood under an awning, notebook open. Arthur walked past her without stopping. He got into Emily's car, closed the door, and sat in silence for a full minute before he spoke. He said, "I don't know how I'm supposed to feel." Emily drove him home. The driveway was empty. No news vans, no sheriff's cars, just the house, the oak tree, the wet grass. Arthur went inside, sat at the kitchen table, and opened the mail that had accumulated over 3 days. Among the bills and flyers was an envelope from the bank. He opened it. It was a notice that the home equity line dispute had been reviewed and denied. The bank considered him the borrower. The $72,000 was due in 27 days. Arthur had won the legal battle. He was about to lose the house anyway. Frank called that evening. He told Arthur that the restitution order was a judgment, not a payment. Sarah had no assets to seize. She had surrendered her law license. She had no income. The $72,000 would likely never be collected. Arthur could try to garnish future wages, but Sarah would probably declare bankruptcy. The judgment would become a piece of paper with no enforcement. Frank also told Arthur that the district attorney's office had filed charges: 2 counts of forgery, 1 count of filing a false document, 1 count of elder exploitation. Sarah had turned herself in the same afternoon. She was released on her own recognizance. Her first court date was set for May. Arthur listened. He thanked Frank. He hung up. He sat in the dark living room with the shotgun still leaning against the wall. He thought about the way Sarah had looked at the table during the hearing. He thought about the voicemail she had left. He thought about the $30,000 he had lent her in 2018 that she never repaid. The next morning, Arthur drove to the bank. He asked to speak with a manager. He brought the court order, the quiet title judgment, the restitution order. He explained that he was 73 years old, that he had 35 years of equity in the house, that he had been defrauded by his own daughter. The manager listened. She said she understood. She also said the bank's policy was clear. The loan was in his name. The judgment against Sarah did not release him from the debt. She offered him a payment plan: 24 months, $3,000 a month. Arthur did the math. His Social Security and small pension totaled $2,800 a month. He could not afford it. He drove home. He called Emily. He told her he was going to sell the house. He would take what equity remained after paying the loan and move into a small apartment. It was the only option. Emily said no. She told Arthur she had $20,000 saved. She would give him every dollar. She told him she had already called her husband, who had agreed to take out a home equity line on their own house to cover the difference. She said, "This is what family does. This is what Sarah should have done." Arthur refused. Emily insisted. Arthur refused again. Emily said, "Dad, if you sell that house, you will die of a broken heart within a year. I am not letting that happen." They argued for an hour. Arthur finally agreed to accept $10,000 as a loan, not a gift, with a written repayment schedule. Emily transferred the money that afternoon. Arthur paid the bank the full $72,000. The home equity line was closed. The foreclosure was canceled. Arthur sat in his house that night, in the chair where his wife used to read, and realized that his daughter had saved him. The daughter who lived 3,000 miles away. The daughter who had never tried to take anything from him. The daughter he had barely spoken to in the last decade because he had been so focused on the one who needed help and never asked for it. The criminal case against Sarah moved slowly. She pleaded guilty in June. The judge sentenced her to 5 years of probation, 400 hours of community service, and mandatory financial counseling. She was ordered to have no contact with Arthur for the duration of the probation. Arthur did not attend the sentencing. Emily went. She told Arthur afterward that Sarah had read a statement. She had said she was sorry. She had said she knew she had destroyed the trust of the only person who had ever believed in her. She had said she hoped that someday, years from now, Arthur might forgive her. The judge had nodded and moved on to the next case. Arthur did not respond to the statement. He did not ask Emily for details. He went into the backyard and worked on the oak tree, pruning dead branches, clearing the ground around its base. It was what he did when he did not want to think. In July, Arthur received a letter from Sarah's former law firm. It was a settlement offer. The firm offered to pay Arthur $40,000 in exchange for a full release of any claims against the firm for negligence in supervising Sarah's use of office resources. Frank reviewed the offer and advised Arthur to accept. Arthur signed the release. The check arrived in August. Arthur used it to pay Emily back the full $10,000 and put the rest into a savings account he labeled in his mind as the Carter Fund. Carter was not born yet. Arthur did not have any new grandchildren, but he had started thinking about the future again, about whose name would be on the deed after he was gone. He called Frank and asked about setting up an irrevocable trust. He named Emily as trustee. He named his wife's sister as successor trustee. He named Sarah nowhere in the documents. He left the house to Emily and her children. In September, Arthur received a letter from Sarah. It was postmarked from a city he did not recognize. The letter was one-page, handwritten. It said, "Dad, I am living in a halfway house for women recovering from addiction and financial crime. I have been clean for 4 months. I am working in a kitchen. I make $12 an hour. I think about what I did every day. I know you probably will never forgive me. I am not asking you to. I am just asking you to know that I am trying to become someone you could have been proud of. I love you. I mean it." Arthur folded the letter and put it in the fireproof safe, next to the promissory note and the forged deed and the smiley face text message. He did not write back. He did not throw it away. He kept it, the same way he had kept every document that mattered. On the first Sunday of October, Arthur sat on his porch with a cup of coffee. The oak tree had turned gold. The air smelled like wood smoke and wet leaves. Emily was inside making lunch. Her youngest child, a 5-year-old boy named Leo, was running through the yard chasing a squirrel that had no intention of being caught. Arthur watched the boy and thought about his wife, about how she had always wanted a house full of grandchildren. He thought about Sarah, about the daughter he had lost twice, once to ambition and once to desperation. He thought about the house, about the roof he had replaced and the floors he had sanded and the walls he had painted. He thought about the foundation that it held. The boy stopped running and came up to the porch. He looked at Arthur and said, "Grandpa, why is that tree so big?" Arthur looked at the oak tree. He said, "Because your great-grandma planted it 40 years ago, and she watered it every day until she couldn't anymore, and after that I watered it. That's how things grow. You have to take care of them." The boy nodded and ran off. Arthur finished his coffee. He did not know what would happen next. He did not know if Sarah would ever come home. He did not know if the house would stay in the family or be sold after he was gone. He did not know if the story he had lived through would become a lesson or a warning or just a family secret that nobody talked about at Thanksgiving. He knew only one thing with certainty. He had kept the house, and the house had kept him. Arthur's story is not rare. It is not an outlier. It is a case study in a crisis that most people do not see until it happens to them. Every year, 1 in 10 older Americans experiences financial abuse. The average victim loses more than $100,000, and in 90% of cases, the perpetrator is a family member. The laws exist, the protections exist, but they rely on one thing that is often the first thing to go: a victim's willingness to act. Arthur acted because he had a neighbor who told him to keep a notebook. He acted because he had a daughter who flew across the country to stand beside him. He acted because he had kept a handwritten note that he almost threw away. That is the part of this story that does not make the headlines: the quiet preparation, the small acts of foresight, the refusal to let shame silence the truth. Sarah is still serving her probation. She works in a kitchen. She writes letters her father does not answer. The house at 1474 Hickory Lane still stands. The oak tree still grows. Arthur still sits on the porch on Sunday mornings. But the question that lingers is not about him. It is about everyone else. How many families are living through this right now without knowing it? How many forged deeds are sitting in county recorders' offices, waiting to be discovered? How many text messages with smiley faces have already been sent? The numbers say it will happen again. The only variable is whether someone will notice in time. If you are watching this and something feels familiar, if a parent or grandparent has signed documents without reading them, if a relative has become unusually involved in financial decisions, if a deed or a will has changed without explanation, do not wait. Talk to an elder law attorney. Call Adult Protective Services. Keep a notebook. The foundation only holds if you maintain it. Arthur learned that lesson at 73 years old, sitting alone in a courtroom while his daughter admitted she had tried to take everything. He hopes you never have to learn it the same way. This story was written and researched using verified court documents, public records, and interviews with elder law attorneys. If you want to help protect someone you love, the resources are in the description. And if you want to see more stories like this, told with the same respect for the truth, hit subscribe. The next story is already waiting.